Yeah, it'll be very interesting to see how that plays out, especially as the cross-examination will likely start tomorrow. And of course, when they end up calling their case, whether they even call former President Trump to the stand. Is there anything I haven't asked you about how you expect this trial to play out, whether Trump himself may actually take the stand or not, or anything, any other observations you have that I haven't asked you yet?
I think that the decision of whether former President Trump is going to take the stand is very much going to rely on the effectiveness of the cross-examination. If the cross-examination of the prosecution's witnesses goes well for the defense, then I believe the chances of putting former President Trump on the stand go down significantly. The judge did make a ruling that if former President Trump does take the stand, they're going to be able to talk about the E. Jean Carroll case. They're going to be able to talk about other settlements he made. This is not a Pandora's box that the defense team may want to open. Typically with a defense case, you want to keep it tight and narrow, and you want to limit other facts and potential evidence that may not be relevant to this case at all. You don't want your client getting painted with a broad brushstrokes of negative allegations that could then prejudice the jury or bias them and say, oh, well, in light of all this information and these other case with E. Jean Carroll, wow, that was a lot of money that Trump lost in that case. He doesn't seem like a great guy, and then use that to color their thinking specifically in this case. So I think that Judge Merchant's ruling is going to give the defense some pause. Usually when a defendant decides, okay, I am going to testify, it's not like it's a last gasp or that it's a last ditch attempt to save your case, but it is highly risky. It has to be very measured and controlled, and most defense attorneys in a criminal trial are very wary of putting their client on the stand because it can open them up to a lot of questions, and they have an absolute Fifth Amendment right to not testify against themselves. And that's a powerful constitutionally protected right. And so you want to do the best you can going through cross-examination, minimizing the case, presenting your own evidence. It's not necessary in most criminal cases to put the defendant on the stand. So I think that's something to keep an eye on as this develops. And also I'd be keeping an eye on what evidence is actually coming to light. Are there text messages? Are there agreements? Are there phone logs? Are there emails? Documents can be very powerful form of evidence because they put things in black and white, and they put things in black and white that are hard to get away from and hard to deny. And then you could show that to the jury and say, ladies and gentlemen of the jury, there is no question that on so-and-so date, this email was sent between these three individuals who agreed that squashing the story would be a good thing for the 2016 election. We don't know whether that exists or not, but it's something to definitely keep an eye on.
Yeah, as you said, the actual documentary evidence and black and white rather than testimonies, what the jurors are going to be looking for, and of course, observers as well, and analysts. And to your point about putting Trump on the stand, he hasn't so far taken the stand in his civil cases. So it'll be really interesting to see if that has any advantage for him in his criminal case.